Hello, everybody. Welcome back to bonus stream. We are doing a bonus stream tonight because we are following the Karen Reid trial, and they were doing their oral arguments for motions in limine in court yesterday. So we need to get in the Wayback Machine and go back to court because they're back in court again tomorrow. And I know me. And if I waited until Sunday, we were going to have like a 9-hour stream. And I didn't think any of us wanted that. So we're gathered together this evening to take a look at what I thought of as some highlights. Because I've watched this already. The other thing is that docuseries has dropped on Hulu and Max and ID Channel and that kind of thing. And I did catch up on just about all of them last night. There's one more episode dropping tonight. I uh, I have feelings and thoughts about these various documentaries and stuff like that, and when they drop, and all of those things, because, well, how to put this? I, I it was abundantly clear from the first few episodes that they clearly thought that trial was going to be done and over and a verdict was going to be handed down when they were filming this. And that's not what happened. So the interviews and stuff like that changed the game. Why do I bring all of this up? Because in the arguments, Brennan brings up some things that Karen Reid said. So without further ado, welcome. Grab your cuppa, grab your snacks, and I'm gonna go ahead and roll the intro. We're just gonna dive right in because I was smart and I wrote down timestamps, and I have a plan. Let's not say that too loud. The universe will be, we'll fix that plan real fast. So, hello and welcome to The Unfiltered Tea, a show where we say all the things you wish the newscasters said, unscripted and unfiltered. We talk about politics, pop culture, and courts, so pull up your soapbox, pour yourself a cuppa, and let's go. I said I was going to be all ready, and then my in-ears just had an argument with my hoodie. So bear with me for a moment while I fix that. There we go. The hoodie was winning. We didn't need that. All right. I think I have it queued up, not for ultimately where we want to start, but if you have been following this trial at all with anybody, we like the hear ye's that happen in Massachusetts. I love when we're doing different court things. One of the things I absolutely love is all the little regional differences and the regional traditions that just happen because they've done it since 1827 or what have you. And I mean, it's Massachusetts, so we're probably talking 1600 something. I don't know. So that's where I've started, and then we will bounce along. Aw, I sped it up ever so slightly.
22117, Commonwealth versus Karen Reid. Can a counsel identify themselves? Starting with the Commonwealth.
Good morning, Mr. McLaughlin.
Good morning, Your Honor. Adam Malik,
Good morning, Mr. Lally.
Good morning, Your Honor. Hank.
All right.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
We don't need everybody's hellos here. Let us go along. Okay. Oh, no. I'm going to let the judge. Don't mind me. I had a plan.
I told counsel before that I had reviewed. So hearing from
No.
counsel, I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been
I'm going to pause her for one moment. One, because I've been messing with the audio, which I swear was fine earlier, and now it's not. Whatever. If you are just hopping in and you have missed all of this, the defense attorneys are in big trouble. Big trouble with the judge because some of the experts got paid, but it was after trial. So when they filed things that said we didn't pay them, my personal take on it is that it was a truly honest mistake, but sometimes in court it doesn't matter if it's a truly honest mistake, it's still a problem. Now, I would be fine with everything she says, except the Commonwealth has had some equally major issues and haven't gotten this sort of a speech. So,
been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ACCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ACCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ACCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here,
Judge Bev, you're going to have to hang on a second because I have everything all the way on max. I do believe. I'm going to try this one thing. Let me know.
the defense has gone above and beyond its reciprocal discovery
That should be
obligation
better.
and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ACCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation.
She did emphasize the word material for a reason. What that means is that, now again, see all of the attorneys that I've linked below for better explanations, but the fact that she emphasized material means she thinks this had an effect on the case.
Violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
Okay. We can skip, zoom, zoomy, zoom. All right.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Mr. Yannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling.
So to summarize, the defense attorney got yelled at. They got brought into the principal's office and told, bad lawyers don't do that again. What is interesting is that, as I understand it, there are several sanctions that she could have imposed, and yet she didn't. So my personal thoughts on this, based on the folks I watch and the things I've seen, and some thoughts forming in my head about this, is that this was all performative for the Commonwealth for reasons I do not understand. Because, well, we've seen when attorneys do bad things. And if she had half of this for the Commonwealth, it would make me feel better. She doesn't. So that's a problem for me. So now I'll let her finish her
On that. So
speech.
we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Oh, I'll give Alessi a little bit of time. We love Attorney Alessi. He likes big words. You're gonna want to grab a dictionary. I do have them sped up, by the way, ever so slightly. I have them sped up to 1.25 because otherwise we'd be here until tomorrow. Well, we'd be here for like 2 hours.
May it please the court. The proposed testimony supported.
I'm going to do this a lot. Camera guy, can you please, or gal, I don't care, do everybody a favor. Stop zooming in on counsel table. Stop it. Focus on the person speaking.
By the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony, by his own report and the Commonwealth's own motion, is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of...
I am being told that I still have mic I truthfully, I don't know how to fix it. I do not know how to fix it. I can't find a single setting anywhere that it's fine for me. It's fine on my end. So I apologize for the audio, guys. I don't know how to fix it. I have a notion as to what the reasoning is, but I I don't know how to fix it. I'm gonna try and play the video again, and maybe I'll take myself out and try something else. I don't know. I'm gonna try.
Of his qualifications. It is essentially Hornbook law that to testify about the manner of death, as opposed to causation, is cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, one paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism.
Okay, we heard a lot of big words. I'm gonna zoom because this goes on for quite a while, and basically this is a motion to get this neurosurgeon or neurologist, I don't know which, not to testify to things involving reasoning around the death of the decedent. And yep, my apologies, because we're gonna use this stream. My apologies for the low audio. Streaming is dynamic. We're just gonna run with it. Okay. All right, we're gonna give Brennan. Go back, Brennan. There we go. As we like to often say, court is generally recorded via potato, and I apparently picked a beat that went with the potato.
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. Simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached.
Brennan, it's like I know that the word of the day for you was now neurosurgeon, because you've said it a stupid number of times in a very small window.
In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury.
Brennan, you're going to 1.5.
Was the leader and director of the Miami Neuroscience Center for 17 years, 1993, 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries.
This is your reminder that this is the same man who wanted to keep out Dr. Russell, whose CV is like the size of a novel. KK.
We can see in his research listed on page 4, he's principal investigator in VAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has
Okay. So I'm going to summarize now because they're going to go back and forth a little bit of Alessi saying he doesn't have the credentials and Brennan saying he does, and Alessi saying bring the receipts, and Brennan saying I have them. Judge will figure it out. This is going to be part of the battle of the experts. Fine. But we are going to skip from that. Let me go ahead to we're going to zoom to all I wrote down was first defense motions. So
Both on this?
there is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like,
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step that it be introduced into evidence.
right. Okay. So in a lot of courts, if you watch as much court as I do, you'll see big posters and things like that, things that make things a little bit clearer for the jury, the witness, that kind of thing. This is a demonstrative that in trial number 1, they were allowed to show to the witness, but not the jury. And what they're asking for this time is to be able to show it to everyone so that we can all see it.
she adopted? Was there? Okay.
She did indicate, and that's part of my argument, Your Honor, which
So go ahead. I'll hear you.
I'll truncate it to relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will
So
recall.
let me just have, so you're just trying to use it as a chalk, not an exhibit.
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into 2 different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very.
And yes, I will slow Alan Jackson down ever so slightly because he speaks a lot faster than everybody else. And in Massachusetts, apparently they call these demonstratives chalks, referring to chalk on a blackboard when folks used to use that. Fun fact. Fun things we learn.
Let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Be a partial objection to a chalk, some of the labeling. I have less concern with a chalk as I do an exhibit.
I mean, so we can take it in 2 steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is
Sure.
this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places, at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
No,
right?
this is more attended to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
Right, because we have the pieces of taillight, but then there was also glass found on the bumper of Karen Reid's vehicle. And I believe there was also some glass on the lawn of 34 Fairview, but I don't remember. I'd need to go back and watch trial 1 for that.
These were a bunch of pieces of glass that were that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex. The court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult.
Yeah.
It was difficult for me to follow. It was even
It was
difficult for
rough.
Candace to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the date of her testimony?
gosh,
Ms. Little, do you have that?
Ms.
transcript?
Little probably has it.
So obviously, I remember her testifying. I remember seeing this previously.
Okay. June 5th, 2024. Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Handley. We showed it to her on the witness stand, and she did adopt it. And she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence. What matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Handley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right.
That is fair, and that is excellent. And part of the reason they want the jury to see it is because if they were getting confused, then I promise you the jury zoned out. And I think the Commonwealth is probably trying to keep it out because it does not help them much.
What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names should be in there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car.
This is an accurate representation of what was presented in the documentary, according to what Karen Reed says. That is, John went up to 34 Fairview. He took her vodka soda glass out of the car. That's a whole different conversation. And headed to 34 Fairview. So that is accurate. Brennan has provided accuracy, which is rare. So we accept that. That is wonderful. Part of the reason this is going to be a fight is because if memory serves, there was unidentified glass that was in this exhibit and that was testified to by this expert. If we now know that there was this glass that John had in his hand that is different than the cocktail glass that he was found with, that leads to more questions, which means more fight, which means more evidence.
Now,
In,
that is
out,
the first
arguments,
time
what
we've
have you.
had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have.
Okay. Maybe you didn't hear, I'm just guessing. Maybe she never said it before, or maybe you never heard it before because you never stopped to listen to her ever. Both things. Both things could be true. I don't know.
This evolving or new testimony or statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful or important. But looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
That is fair.
All right, so
To be fair to Brennan,
hold off and see where
that
the
is
fence
fair.
is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. It's just, I need to hear.
That is very fair. I will take that. We're going to zoom now. To the request to have Karen Reed join everybody at the jury view. So, what nobody disagrees about, one of the motions is to have the jury all go out to 34 Fairview to see it in person because, well, if you're anything like me, if you haven't been there, there is no way that your brain, I mean, some people can do it, Dad's brain can do it, but me, I can see pictures, but it doesn't mean anything to me unless I am like physically there in the space. And then if I can see how close things are or how far things are or whatever, it can make a difference as to, oh, this theory of the case makes sense. That theory of the case makes sense. No theories of the case make sense. So jury views, fine. Nobody's arguing the jury view. What this is going to be is a discussion over whether or not Karen Reed can go with everybody to the jury view.
Moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry. 562 and 576. So Ms. Little.
Thank you, Your Honor. I'm handling the motion to exclude.
Camera guy, what are we doing?
Has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense.
I apologize. I skipped way ahead or I wrote down the wrong note. This is going to be different. This is sequestration of witnesses.
Defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken
Like
the stand.
all.
After they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes,
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family.
Yeah. So they were sitting over. They were sitting over with the O'Keefe family that is just beyond counsel table. The jury is where the camera is, so you don't see the jury. They were staring the jury down. It was weird, like staring the jury down.
At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know.
Okay.
He or she was anonymous.
Okay.
I just realized what Miss Little did there. I've watched this, I don't know, multiple times, and you know what I missed? The third-party culprit staring at the jury. So that tells me that they're going with that defense again. And it
Your
was
Honor,
brilliant.
that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously
Yes.
watch other expert testimony that deals with their.
All right, so obviously is not something that should be in a motion, okay? If you've got an agreement that each other.
Judge, I know you have issues with the defense. I've watched a lot of court. Literally no one ever does court quite like Massachusetts, which I'm sure is a point of pride. But that condescending mentor thing drives me nuts. At least she likes Miss Little and Mr. Alessi.
There's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted, okay?
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, and I don't want to speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right, so you all need to talk, all right? And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given, okay? All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable.
Sir, it was a juror. It was a juror. It was a finder of fact that was intimidated, but it was. Go back if you have not watched trial number 1. Go back and see back in this area back here, right above my head, right here. This is the bench area where they were. And they were all like, my memory of that was that they all came in and just stared the jury down. And I can't remember. Some of them may have even been in uniform because that's not intimidating at all. I don't remember. Don't quote me on that. I don't remember off the top of my head. But I do remember thinking it was real weird when it happened. So, I can see the argument for keeping him out of the courtroom.
It seems as though the presentation has a deliberate point to promote a cause, but doesn't have any sense of balance or fairness whatsoever. All witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential.
Sir, almost none of your motions have grace at all. Also, that courtroom looks like it's the size of, I don't know, a broom closet. And there's a million people available that are streaming this. So maybe just,
family members.
watch it from somewhere else.
And certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in a courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair. It's just.
That part I agree with. That is the family of the victim and the family of the defendant. That is fair. That's not the argument.
Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during the closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I actually deny the idea that these targets of the defense should not be able to attend the closing.
Oh, come on.
That would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
I'm with you, Mr. Reed. That face is that. Because the thing is, I don't agree with his under normal circumstances, I would agree with his reasoning. I think it could be a problem here. All right, where are we jumping to
Yeah,
next?
sure. There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
Right. So we're going to make a record because this defense team is great and they make all of the records, which also means it can take a while. Okay. Let us zoom again a little bit. We're going to go past the OnlyFan to, I'm just going to do a little bit on here, but we won't hang out for too long because, yeah, we'll give it like 5 minutes or so because it's interesting. And I didn't know any of this, about panel voir dire versus individual voir dire. So let me embiggen myself and we're going to have a moment and I'm going to go through jury summons and things like that. Because do I know? No. Am I an expert? No. Has anybody ever called me for jury duty? No. And if I get a summons now, that'll be real interesting because I'm like, I watch all of these attorneys and I work at a firm. Please put me on the jury. And they're going to be like, no. Fine. So the summons go out, right? So you've got this trial coming up. This is how I understand it. Hey, please feel free to correct me if you know more than me or you know regional differences. Because I'm curious to know how accurate I am from picking up on everything. So we know this trial is set for April 1st. So there is, I can't remember their title now, but the person who decides these summons are going to go out, basically the person doing the jury initial bingo lottery, right? So the summons goes out to, call it 300 people, along with a questionnaire. And the questionnaire basically says, hey, have you heard of this case ever at all? Do you know anything? And most of us are sitting here going, well, of course everybody's heard of this case. But honestly, like, the folks in this house wouldn't necessarily have heard of it if I hadn't gotten hooked on watching everything. So you can find people that are like, I don't know. Yeah, I've seen some headlines and that's about it. So based on that questionnaire, then you get a group of people to actually come down to the courthouse and then the attorneys ask them questions. There's usually a paper questionnaire that weeds out a whole group. And then there's in-person questions where they ask you different things. Like in this case, do you have family in law enforcement? Or how do you feel about people driving under the influence of alcohol? Because those very strong feelings will come into decision time on a jury. So Alan Jackson is making a motion to have panel voir dire, where basically you take 12 people and you stick them in the box. This is how I understand it. Again, reference attorneys for better explanations. But you take 12 people, you stick them in the box, and you see what their chemistry is. You see if they, chit chat, that kind of thing, and you voir dire them all together. Now, based on what the judge will be saying and based on other explanations, what I understand is that if one person is like, oh yeah, I follow everything. I'm on the Unfiltered Tea every time she does an episode. I watch all of the attorneys. I watch court TV, all of that. Then the whole box is yeeted. So Alan Jackson wants panel. And
all I need you to
Yeah.
really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law
It helps if you can see Alan Jackson instead of my face. Sorry.
enforcement or vice versa.
Whoopsie
Beliefs about
doodle.
driving under the influence, we think that's attendant to this particular case in particular. Involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights.
Okay. Well, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel one year conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is some, at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay. Is the Commonwealth's position?
That is a fair argument.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I would say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or a follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience,
Look, they agree.
Where I'm from is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire. But I want you to agree to it. And if you can't, I need that. I need that by the end of today if you're not going to agree to it. Have you proposed
that is fair?
Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we can act on to start with.
So let's do that. What Mr. Brennan's new to the case, when I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing,
this judge really likes to keep everything on a nice tight clock. And with this group of folks, more than one page, and they'll be there until midnight.
Tomorrow, I'd like to talk about the particulars of it. We have a huge amount of jurors coming in. I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire.
Yeah.
So 566 then is denied because it's requesting panel voir dire.
Hey, look, she rolled from the bench on something.
Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies?
It should apply to both sides, Brennan, but that motion came in because they found out that folks were having chit-chats in between their testimony at lunchtime.
To both sides. Ms. Little.
Thank you.
Okay.
So, yeah, keep it the way it's
Next, so
supposed to
that is
be.
to Clerk 567 allowed as to both sides.
Okay, let me jump ahead. All right, right. So the defense also had a motion to try to keep out the witness intimidation testimony. If you watch trial number 1, you remember Jen McCabe's very, very pointed things. Here's the deal with that. I'm on the internet enough that I see a lot of the back and forth. Now, I am very lucky and I hang out in chats with great mods and with a pretty clear, how to put this. The most of the people in the chats that I hang out with are there because they want the facts. They aren't, if it has not been presented in evidence in some way, everybody's kind of taking it with a grain of salt. Not everywhere, but for the most part, and therefore folks are respectful and things like that. I will say that and I have seen it on both sides. Don't take it real world. Don't be really, just don't be a dick. Don't be a dick. Don't be a dick. Don't harass people. Don't follow people to their house. Don't tell them that they're idiots or what have you. But also, they shouldn't be doing that either. And I don't really care which side you're on, but it has gotten kind of crazy down there from all of the footage and things like that. The places that I have been, online, internet, that kind of thing, the Karen Reed is guilty crew, from what just my eyeballs have seen, have been far nastier and far louder. I'm not saying it doesn't happen on both sides. It absolutely does, but they have been, and that's just what I've seen. I know it goes both ways. Mostly just stop being that. And if you truly, here's the thing. Okay, and begin for a minute, because here's the thing. If you honestly believe, if you are steadfast in your belief that either Karen Reed is guilty or Karen Reed is innocent, it does not really matter. You know what? Just, you are not on the jury. Let the jury decide. Watch the evidence. Watch the new evidence that comes in. And if you want to make the other side look worse, be kind, be understanding. Just listen. And if they're not going to listen, then, take a leaf from our friends who live down south and say, well, bless their heart, and leave it alone. Okay, soapbox over. Okay. Back to this. So, I'm not gonna go with the defense's motion for this, mostly because if you watch trial number 1, Alan Jackson didn't think he stepped in it, but he kind of stepped in it, and then it opened the door, and so him and Judge Cannone are having a back and forth as to whether or not he should kick in the door again, and clearly he's saying, yeah, no, I'm not going to kick in the door again, but Brennan is new, and he has a few things to say, so... all right.
On that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Miss Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And
I'm going to call this out. He said sharing anything public with him. Okay. That means it's already public information. Uh, sir, did you hear the? Okay.
choose.
Kudos to the cameraman, though, because at one point, so Aiden Carney is actually sitting in here because he is a YouTuber and all of that. And the camera guy did actually zoom in on him at one point during this. It was pretty entertaining.
To be oblivious, to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity.
You know, I don't know what the indictments are for or what the evidence is coming in, but just because he's in court doesn't mean he's guilty. I'm just saying. It doesn't mean he's innocent either. But just because you've been indicted and you're in court doesn't make you we have to remember that. Brennan seems to have a hard time.
To hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have because that
Right, because you tend to not have it.
inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it.
I don't know. It was her testimony in trial 1 did not sit well with me at all.
And to suggest they can stand here and bash witnesses in the
Sir.
text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family event.
Really? That's what you went with? That's what you went with? Patting the bloggers on the butt for a job well done? I mean, it is objectively hilarious. But sir,
That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door.
the baseless accusation he is talking about is there is a single deleted Google search on Jen McCabe's phone that was a big deal in trial number 1. And it is problematic for her.
And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue and an attorney having control of their questions so they don't open the door. That really is the issue.
So
Really,
you agree it doesn't
Brennan?
come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door.
I remember watching this and it was not clear to me. So I don't know. Maybe I just live in a different
I have
place.
no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Wait, that was a lot. That was a whole lot of
Your Honor,
record.
if I may very briefly.
Sure, just give me 1 second. I want to take one note.
Of
Okay?
course.
for sure you can do this. But it got Alan Jackson
I
up to
just
say
wonder
something.
if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury.
So, in case you're wondering, Aiden Carney is the first laptop up. You have Alan Jackson, and then the family, and then Aiden Carney, who just made quite a face. It's very meta.
And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice.
Okay, we're gonna skip past the hyperbole. It is the battle of the hyperbole, which frankly Jackson and Brennan are both real good at. Okay, so now let us scoot ever so slightly. I think, yeah, Alan Jackson talking about toning down the drama is, uh, mm. You know what? I think we're gonna skip the arguments for the retrograde extrapolation, because some of this, the Commonwealth wants to bring in this blood test that was done when Karen Reed was brought to the hospital. Because if memory serves in trial number 1, what they used to determine what her blood alcohol content would have been at that time, I was left with a lot of questions myself about it. It's a lot of sciencey things, and it will get down to who can explain it better. I feel like this would be a great band name too, the Battle of the Hyperboles. Bonus if they're nerds. You know. So yeah, so the defense wants to keep that out because they view it as being a bad test. The Commonwealth wants it in because, well, it helps their case. So, but I think we're going to skip that and we're going to pop right ahead to the end of the day because it's a lot of sciencey things. And we've already been here for a while, and I'm trying to keep this where it is. If you're a nerd like me, it's a great watch. If you are not so much a nerd like me, it can get kind of a lot. So, we are going to get to the formal motion to continue the trial. Translation, the formal motion to say, hey, can we put a pin in this for a few minutes? Because we've got other stuff going on because there's appeals happening right now and that kind of thing. So I will bring it down to here. There we are. And we will watch the rest of this. And I am actually going to, well, we'll see. We'll see how long I last on normal speed, guys.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge.
That appeal is trying to get rid of counts 1 and 3 and just leave count 2, the DUI charge. And it's, no, we're not doing that. Well, anyway, it's
Sailor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because that's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
no.
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay.
That would be
I appreciate that. Did I say
the court.
Thank you.
The court
just indicated that it's Monday.
attorney there.
Opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much.
Of course.
Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Yeah, better to have him just get up and explain it.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure.
Yes, thank you. Thank you, Judge.
Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charge.
That would be huge. Because, see, if let's say the appeals court says, no, she shouldn't have been charged with counts 1 or count 3. That's a new trial. So if you're mid-trial and that comes down, that's a giant scheduling headache. Never mind everything else.
At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps it's fair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in,
Right.
their schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take.
Mhm.
So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment.
Mhm.
Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one?
And I am going to call that there because it seems so. Oh, you know what? I'm going to swoop. That's what I'm going to do. I'm going to swoop. So that was motions in limine day 1. They are back in court tomorrow, and it's either going to be a long court day or it is going to be 10 minutes based on the motions that were coming out today. There has been a request to continue the case to April 28th as opposed to starting on April 1st, which gives a little bit more time for things to run through the appellate courts and things like that, and a little bit of time for the new publicity to either die down or ramp up. Who knows at this point what that's going to mean. So tomorrow could be a super short court day, or it could be a very long court day, and that's why I wanted to do a show tonight and hang with everybody tonight, so that on Sunday we weren't sitting there for 3 hours trying to recap stuff. So for me, selfishly, because I've got some things coming up on my end, I would love it if court would continue. I know that if you're following a bunch of different cases, that could be more of a headache because then things start to overlap and then you have to catch up, and it's just, but for me personally, it would be great if we could just, put a pin in it for a little while. Anyway, let me know in the comments and things like that if you want the new docuseries to be a part of what we talk about on Sunday if tomorrow is short, because I do have some thoughts on that. There are some interviews and articles surrounding that I can pull up, and we can go over those sorts of things. everybody's back in court tomorrow. I will be keeping an eye on that. But yeah, the rest of my week is kind of jam-packed, so we will gather again on Sunday. Sunday, we might even look at some headlines too on the news. I don't know. I'm still here, so that's good. So Sunday we'll cover a few headlines, and go back to court and go over all of that as well. If there is any of those that you see that you want me to bring up or chat about, or you want to chat about it, drop it in the comments. With that, we've reached that point. We're an hour in, and I always forget to do this. Do all of the YouTube things if you're hanging with me. Go ahead and like the stream and subscribe. If you want to keep hanging with me, that would be great. Ooh, and if you do like everything and you do want to keep hanging with me and you want to talk to your friends about it, share. So, all right, now I've done all of the streamer things that need to be done. That was court day. We are here. Where's my little cheat sheet? I have lots of cheat sheets. Do I need them? I don't need them. We've reached that point in the evening where I'm going to say thanks for hanging with me. Thanks for joining us on this little ride. And as always, be well, do good, and remember, bark a lot. Thanks for joining us for another episode of The Unfiltered Tea. Don't forget to hit that like button. If you have a story you want our unfiltered take on, go ahead and drop it in the comments, and we will see you next time.